Today, the defense is fighting for the ability to continue to speak freely with the public. Prosecutors say the defense could taint the jury pool because of its interactions with potential jurors over social media. They also accuse attorney Mark O'Mara of inappropriately challenging evidence before the case goes to trial. And joining us now for more details is my friend, in-session correspondent Gene Casares, who will be guiding us, of course, through the motions. Also, criminal defense attorney and CNN contributor Mark NeJame, criminal defense attorney Darren Kavinoky, and in-session law enforcement analyst and contributor Mike Brooks. We have a full house for this very important hearing. And Gene, let me turn to you first. Can you give us just a rundown of the state's memo and motion for a gag order in this case? Because it's quite unusual, isn't it?
You know, and we think about gag order, and I think we all understand it, but it's interesting what they really put in this this memorandum is the purpose of it, to ensure the fairness and the integrity of the judicial process. The prosecution is afraid that they will not be able to seat an impartial jury if the attorneys are not gagged in this case. And here's just a little excerpt from the motion that I think puts it all in perspective. Unless defense counsel stops talking to the media as described in person or by use of the internet and social media websites, it will be impossible to select an impartial jury that has not been influenced by the biased comments of the defense counsel. And, you know, I think, Sonny, what just makes this just state-of-the-art and really a precedent for cases all across the country, high-profile trials, maybe trials that are high-profile to a community, is the fact that there is a website. There are commentaries. It is by the defense team. They ask for questions and then they give answers. And so there is a freedom of expression here, but it's the social media aspect that I think makes this gag order request unique.
And we're looking right now at a live shot of the courtroom. Again, we're counting down to the hearing. We're about 25 minutes away from the hearing. The judge, the last hearing, this new judge, got on the bench a bit earlier, so that's why we're showing you the courtroom right now, because it may start earlier. But I want to go to you, Mark NeJame, because, you know, we are now as attorneys in a pretty different age, I think, with the age of social media and Twitter you know, Facebook and that sort of thing. There's this immediacy of information, of public information, that as attorneys we didn't have to deal with before. I certainly didn't deal with it as a prosecutor. I don't know if you've had to deal with it as a defense attorney. So what is your sense of the chances of the government's argument for a gag order in this case?
Well, I think you and Beth are completely right, Sonny. We're in uncharted waters. We first saw the importance of social media in the Casey Anthony case right here in Central Florida, and now we have this national profile case, and we see that we have in real time people commenting and giving opinions and everything else, and there's so many challenges back and forth. It's not an easy answer. If O'Mara is silenced, which I really don't expect, but it doesn't stop anybody else from going out and saying what they want to. So I'm not sure, like in the old days, it really makes that much of a difference. And then in this particular case, you have Trayvon's family, who was not a party to this case. Of course, they're, you know, the grieving parents of this young man who was killed, but they are not parties, and there's no restriction on them being able to give one side, which is, I think, would be interpreted pro-prosecution. So if you have one side that can't say anything, but yet you have another side that, without restriction, can, through the use or the efforts of somebody technically unrelated to the case, you know, does that become unfair? So, you know, a real conundrum here.
Well, Mark, I have to go to you on this, because you were right at the last hearing when you said you suspected that Trayvon Martin's school records would be released. You're our expert on Florida law. Have you ever seen a situation like this? Because Mike and I both practiced in D.C. I have never seen a judge allow an investigation, or law enforcement personnel to sort of be sequestered from a lead attorney in a case.
No, it's novel, it's unique, and it's not going anywhere. Rules of Criminal Procedure 3.220, basically you cannot limit one side or the other's access to witnesses. So it's just not going to go anywhere. I think the intent of it is that we all know that a lot of times people get their stories together. And so law enforcement may meet and they'll say, well, you know, what about this and what about that? Because remember, some of the defense's best witnesses in this case are going to be law enforcement who deemed that there wasn't probable cause and they didn't believe that a crime had been committed. So what they don't want is other law enforcement or other people getting with them and putting a spin as to why they came up with that decision, so that now they're not as valuable to the defense as they hope that they will be later down the road. I think that it's not going to go anywhere. It's prohibited by the rules of procedure. But I think that's the intent of it.
This is very unusual. Do we have Mark NeJame still with us?
I'm with you, Sonny.
Mark, have you appeared before this judge? Is she known for being this prompt?
She is you called it right on. You're going to find somebody that's going to follow the rules. There's going to be no nonsense. She's going to be very direct. That's her reputation. We have cases, my firm routinely, in Seminole County, and that's her reputation. You nailed it.
Now, you know Mark O'Mara. I don't know him. I have spoken to him several times. He seems to be a very upstanding member of the bar, very timely, has been practicing there for quite some time. Is this an unusual thing? I mean, it's already, I'd say he's about 2 minutes late to a pretty big hearing.
Well, sometimes you do get stuck at the elevators. I mean, you should prepare for it, but the reality of it is that with traffic or elevators or people, going through the security lines and who you might be with, or you bring your folders with you and they get stopped. I mean, you're supposed to be there, particularly in a case like this where really a good part of the country is watching. But you're supposed to be on time, regardless of any excuses. But it does happen.
Now, I want to go back, Mark, to the discussion that we were having earlier, just about social media and how it has been fascinating that not only let's go back into the courtroom. I see someone walking in. It's not Mark O'Mara, though. Do we know who that is?
I'm looking. Yeah, that's Will J. I think, I don't have my glasses on. Let me take a look. No, it's not. Never mind. I just mentioned the wrong person.
Well, it does appear to be someone on the defense team. Perhaps, there's someone else coming in. I feel like I'm watching a movie. There we go. There we go. George Zimmerman has just walked in with his attorney, Mark O'Mara.
There was a problem with some of the monitoring that they just had to try and reset.
Okay, thank you. We're on the record on State versus Zimmerman, case number 12 CF 1083A.